Welcome. Good morning to those of you on the East Coast, or I should say West Coast. Good afternoon to those of you on the East Coast. Warm welcome to everybody in between. My name is Dan, and I will be your employment lawyer for the next 30 minutes or so. You can see my name on the screen, Dan Balkaran, and I'm an associate at Canada's leading employee side employment law firm, Samfiru Tumarkin, LLP. Okay, so as always, send us your questions as soon as you can. A couple housekeeping notes before we get started. If you need to get a hold of us at all, you can do so, or just for helpful information at employmentlawyer.ca. You can email us at help@employmentlawyer.ca. See it on the bottom there. And you can call us at 1-855-821-5900. Okay, so waiting for your questions to roll in here. I understand we have a few just waiting in the queue. While I'm waiting for those, items in the news that affect employment law. There have been, at least in BC, there have been large rounds of tech sector layoffs. Well, that's always, unfortunate to hear, and we wish the best to all those people who've lost their jobs. I'll just talk about that a little bit and just some things that everyone should be aware of. First of all, the term layoff is an unfortunate term because it means different things depending on the context, and it means one thing in law and it means another thing in society. So the layoffs that I'm talking about in the tech sector are not layoffs; they're terminations. Okay, and some people think of layoff and termination as being the same thing, but in law, a layoff is really an agreed temporary interruption of your employment that both parties, you and the employer, understand is going to be of a finite duration, and then you'll come back to work at some point. So lots of sectors have temporary layoffs built into their employment. And of course, famously, huge amounts of the Canadian workforce were placed on temporary layoff when the COVID-19 pandemic hit. And of course, each province deals with that differently. That's different than effectively what these tech companies are doing, which are terminations, where the employer is letting the individuals go and they're never coming back. There's no expectation of them coming back. And so the important thing to understand as far as our conversation today is, in order to get severance, which is effectively money for your termination, you need to get to a without cause termination. Okay? And so a temporary layoff isn't going to get you there, but an actual termination of your employment is, and then there's a whole bunch of legal questions after that in terms of, or an evaluative process to determine what your legal position is. But for the people who've lost their jobs in the BC tech sector, before you sign anything, you should always speak to a lawyer. You need to understand whether or not what is being offered to you as a separation package, if any, is commensurate with your legal position. You don't want to leave money on the table. Talk to a lawyer, find out exactly what your legal rights are before you put pen to paper. Because once you take that money from the company laying you off in exchange for your signature on a release, saying that you have no claim against that company in the future, you're done. You have no case. And so if you learn later on that you left 80% of your severance value on the table, there's nothing you can do about it. Okay, so talk to a lawyer first. To that end, if you need to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, great. Let's get into your questions. They've rolled in here now. So from Patricia, my position originally required me to work 1 week in a different location in a different town. My employer wants me to move there permanently, but I can't do this for medical reasons and time restrictions due to the travel. Can my employer change my location? Oh, this is a really interesting question. So let's circle back around to what I said earlier. Your only legal right in the event of your termination is severance. Okay, so your employer can just do it, and the question is it a constructive dismissal? Okay, so the question is the actions of the employer, or are the actions of the employer a termination, a de facto termination, such that you can trigger your severance? And would you want to do that based on what your employment contract says and your age, your length of service, and your position? So the short answer is if you say there's no magic where I can, you can hire a lawyer and the lawyer can prevent your employer from doing it. It's just, what is your remedy after the fact? I do think, though, if you have bona fide medical reasons for not being able to do that, I don't know what those are, but if your doctor says, you get a medical note saying Patricia cannot work in this other town, or cannot move on a permanent basis to this other town, she can only, work there maximum 1 week a month, or whatever you're currently doing, and you give that to the employer is going to look at that, and certainly they're not going to be happy about it, but they're going to have to consider that, right? Because then at that point, if they then do it anyway, not only are they potentially constructively dismissing you, but they're also violating your human rights, which nominally attracts other compensation. So that you could be entitled to. In terms of the analysis of constructive dismissal, constructive dismissal, which you've all probably heard of, is where your employer's actions in effect terminate you. So through their actions, they have terminated your employee. And so the classic example there would be if they reduced your pay by 50%. Okay, well, so you're not working under the same contract of employment that you were when you first got hired, or at least immediately before the pay reduction, and therefore the employer has effectively abrogated its contractual relationship with you, such that you've been terminated. So it's just actions by employer de facto terminate you. The question, the operative question, in whether or not, because you have to get to termination, actions of employer are considered by the court to be a termination. You have to get to termination. In order to get there, you have to evaluate what was in the reasonable contemplation of the parties at the time of contract formation. Okay, and so you originally were required to work 1 week a year, or 1 week a month, I guess. I'm assuming one week in a month in this different town. Is it based on the relationship or on contractual documents or any emails? If there's oral representations and your contract allows for that, can they plausibly say, no, we were going to ramp this up and she always knew this was a possibility? If that's the case, then you potentially don't have a case for constructive dismissal. Okay? Also, if the town is 10 minutes away, you probably don't have a case for constructive dismissal. Town's 2 hours away, then you probably do. It just depends on what's in the reasonable contemplation of the parties at the time of contract formation. It's a famous case. I can't remember it. I think it's an Ontario case that I looked at once before that contemplated just that. And I think it wasn't a constructive dismissal because it was in the contemplation of the parties at the time that the relationship was formed. This person was an executive, but that they might move him across the country to a different office. So it depends, right? And so Patricia, you should 100%, I'm going to sound like a broken record today, but you should 100% talk to an employment lawyer. Again, you can get a hold of us at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Thanks. I hope that answered your question, Patricia. Archie, if I agree to a layoff due to COVID, does that mean I have to accept any future layoffs? Is there a threshold to how long a layoff is allowed to last? These are all great questions, and I can't answer them to the degree that you would like. So I'll just start with some foundational material. There's no right at law to, at least under the common law, to interrupt your employment. Okay, so if your employer says I'm putting you on layoff and you say no, then and they stop paying you, you've effectively been terminated. Okay, but if you agree to it, then you're in a state of layoff. Okay, now most jurisdictions if you're provincially regulated, it gets complicated. If you're provincially regulated, most jurisdictions will have a cap on how long you can be laid off for before your employment is de facto, not de facto terminated, is terminated by operation of the Employment Standards Act. In BC, for example, it's 13 out of 20 weeks or 13 straight weeks. It was stretched in 2020 to a maximum of August 30th, 2020. Okay? And then anyone who was on layoff was automatically terminated by operation of law unless they agreed to a variance extending that. But the reason why I said I can't answer this question properly for you is that different provinces did different things, and so temporary layoffs in Ontario, for example, could place you in this status called infectious disease emergency leave, which I believe got extended again, although I'm not 100% certain because I'm not called in Ontario and I don't practice out there. And so it put employees who were in that status sort of in this indefinite holding plan where they couldn't, or holding pattern where they couldn't get determination to trigger their severance. So if that's you and that's what happened to you, I can't answer that question with any certainty because I don't know the nuances of where EIDL is at, infectious disease emergency leave, EIDL. I don't know where it's at right now, and so I would encourage you to talk to one of our Ontario lawyers. Again, help@employmentlawyer.ca, 1-855-821-5900. The second part of your question, though, do you have to accept any future layoffs? So there's an argument if you were placed on layoff. Sorry, let me rephrase that. You agree to a temporary layoff, you're on layoff, then they call you back, and then they want to put you on layoff again. That can't be a constructive dismissal because you've already established a pattern of you've agreed to the layoff in the past. I'd have to look at that a little bit more. I have heard people make that argument. You've in fact condoned the actions of the behavior you've condoned the actions of the employer in the past. I have some problems with that argument, but I understand that it is a thing, that is a possibility. So I need more context, Archie, or anything specific. In terms of your final question, is there a threshold to how long a layoff is allowed to last? Yes, both. If you're federally regulated and provincially regulated, and 90% are provincially regulated, there'll be a threshold. I told you in BC, it's 13 out of 20 weeks. Under the federal, the Canada Labor Code, there's also a maximum. I don't have it off the top of my head, but they're easy to look up. And in terms of whether or not you're federally regulated or not, you can just Google whether or not your industry is federally regulated, and then there's a list of industries that the Canada.ca website lists as federally regulated. Those will be industries that are interprovincial in nature. So interprovincial trucking, banking, telecommunications, air travel, that kind of thing. So if you're sort of in a standard, corporate white collar job, for example, that'll be provincially regulated, and then the threshold for how long your layoff is will be governed by your Provincial Employment Standards Act. But Archie, these questions are jurisdictionally specific, and they're much more fact pattern specific than I can get from just your paragraph. So again, you certainly want to talk to an employment lawyer if something turns on this for you. Okay, Judith. What can I do to deal with workplace harassment problems? It's becoming very bad at my job. Okay, so this is a huge percentage of the people I speak to claim that they are being harassed. Okay, but there's a question of, is it objective harassment or is it subjective, right? And I would argue that harassment has to have an objective component to it. So you have to look at harassment. Okay, there can be sort of two jurisdictional avenues for, at least in BC. I think in Ontario they combine the two. But are you being harassed? And I'll get into what that means in a second. And are you being harassed on the basis of and therefore discriminated against on the basis of a human rights protected ground? Human rights protected ground would be like your age, race, ethnicity, sexual orientation, gender identity, sex, family status, religious belief, criminal record, disability. I'm missing some of them. So, the classic example would be on the basis of sex. So you're being sexually harassed. Okay, if you're being sexually harassed, you have, in BC at least, I mean everywhere, you'll have a human rights complaint. It's just in BC the Human Rights Tribunal is completely separated from the rest of the court system, and it's its own unique jurisdiction and process. In Ontario, I think they merge the two together, but you still can't discriminate against someone on the basis of sex or gender, and so you can't sexually harass somebody. And in BC, you have an avenue of compensation that way. Harassment, other kind of harassment, so we'll say non-sexual harassment, non-human rights protected ground harassment is a much bigger problem. Okay, so employment features humans in a hierarchical system with in which conflict is often part and parcel with the structure. Okay, and so there'll be lots of conflict. I shouldn't say lots, but there is naturally conflict in an employee or employee relationship. That doesn't mean it's harassment. Okay, and so the courts are very loath to and hesitant to classify behavior that might be problematic as harassment to the point where it has some sort of significance. Okay, and the legal significance, and the legal significance that it would have is twofold. So number one, it can provide a grounding for what are called bad faith damages, but you have to have a cause of action to get that. So you've been terminated without cause, and the employer's egregious behavior through that process triggers bad faith damages. Those are rare and small, quite often. A much more likely situation is that your employer's harassment. So I'll back up here for a second. You're entitled to a harassment-free work environment, okay? And if you don't have that, and your employer is aware of it, of the harassment you're experiencing, then the actions of the employer in not remedying the harassment, and or if it's coming from the employer itself, may trigger your constructive dismissal, which would then allow you to access severance damages. But remember that the result of that is you don't have a job anymore, right? So if that's not an outcome that you want, you don't want to necessarily go down that path. But if it is, I advise people. I think I did this on the radio a couple weeks ago. Courts aren't going to, if you say you've been harassed and you cite a couple of stories about how your boss screamed at you, court's not going to find that to be enough to trigger your constructive termination and have severance flow from it. Okay, courts are very hesitant to get involved in that kind of thing. So you need a lot of evidence. Okay, so that would be, corroborating evidence from a colleague, or if you have a recording. Although I'd be careful secretly recording your employers. There was a famous case where that was effectively the trigger for, in BC anyway, for a just cause termination. Or emails from your boss that are harassing, or what I tell individuals I talk to who are in this situation, keep a diary, date, time, who was involved, the actions that were taken against you and what you did. And then this is the tough part. Okay, so if you can eventually in a court hold up a diary that shows 50 pages of harassment with details about what happened, you're much more likely to be believed. Okay, but here's the tough part, right? So you can't just claim, or you're unlikely to be successful if you just claim out of the blue one day, I've been harassed and I claim constructive dismissal. You have to give your employer an opportunity to correct the problem, which means you have to report it, right? And I don't know, if it's your boss doing the harassment, then you have to report over your boss. But of course, anytime you go over a boss, you're likely to have your job ended, right? And so, it's a delicate needle that you have to thread. But if you don't report it, and by email, email or letter or something, so there's a paper trail. If you don't report it, you haven't given the employer notice that this is occurring, right? The employer might get your report and investigate and then stop the harassment, right? And so if you don't do that, it's going to be awfully difficult for you to claim constructive dismissal. So I think in that situation, and anytime you've got harassment to the point where it's becoming really really a problem at your job and your long-term viability at your job is a problem, I think you need to talk to a lawyer before you do anything. Okay, because there are I as a lawyer can clean up a lot of things, but I can't clean up everything. And sometimes you're going to take actions that limit what I can do to assist you. So it's much better to talk to a lawyer ahead of time so you have legal advice guiding your actions. So as you can see on the screen there, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900 is how you get a hold of us. So Judith, I encourage you to do that or to talk to an employment lawyer. The road is not always great when it's just an ongoing harassment problem, but it doesn't mean it's impossible, particularly, given the egregiousness of the harassment. And I'll just say one more thing about that. Harassment, both of a sexual nature and not, it's got really two independent components, okay? Repetition and severity, okay? So a single act of sort of low-level harassment isn't going to trigger your termination, okay? But an ongoing failure to correct that level of harassment will, right? But a single act of egregious termination or egregious harassment or sexual harassment can do it, right? So it's a balance between, or at least you have to evaluate those two factors: egregiousness of the conduct and repetition. Okay, moving on. Question from John. I was let go from a new position after 8 months on the job, and I was offered 2 months of severance. I was headhunted for the position and left the previous position of 10 years. Is the offer adequate, or is it worth my time to speak to a lawyer? That's a great question. So, it's a great question. So, there is a doctrine in employment law called inducement, okay? And it's for exactly your situation. And it's a hard test to meet. There's multiple different portions of it, but basically it says this: if you are in a secure job that you've been at for a while, and a different company comes along and says to you, and you didn't contact them for a job, and they say, John, we want you to come work for us. Here's a bunch of money, or here's opportunity, or here's a promotion. Come work for us. It's going to be great. You're going to have a long career here. Come on over. And then you come over and then they fire you out in the first year, or 2 years, then you have an entitlement to common law severance. Okay, so that depends on what's in your employment contract. Then what can happen is because length of service is the most important of the factors that in common law severance. And so, if you have 8 months of service, 2 months, 3 months, it's fine. In terms of severance. But if you were properly induced, if the court says you were induced to come over, then your previous 10 years of service are grafted on to your 8 months of service, and you become effectively an 11-year employee, or almost. And then you're talking about a best day of 12 months, okay, which is a lot different than 2 months. So is it worth your time talking to a lawyer? Yeah, absolutely, 100%. You should talk to a lawyer immediately. A lawyer needs to evaluate your employment contract and what that's, and the termination letter and severance offer. Okay. Now it's all going to come down to what's in your employment contract. If your employment contract limits you to Employment Standards Act minimums, that offer is good. But if not, particularly if you're in Ontario, because Ontario contracts are much easier to get out of than they are than other jurisdictions. So you saw on the screen, contact us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. 100%, John, you should talk to a lawyer. Okay. Carrie asks, heard some other lawyers on here say there are things in employment contracts that might limit your severance. What should I look out for when I sign a new employment contract? So I don't think a non-employment lawyer is going to have the ability to properly parse out and evaluate, even if I talk to you about some of the things that you're going to look for. You're not going to be able to properly evaluate whether or not your contract limits you to something other than common law severance. I can't even imply that, because that would be incorrect advice to give you. I'm going to say right at the outset, there is no substitute for legal advice. I sound like a broken record today, but if you have a new employment contract that is given to you and you are worried about how it potentially limits your rights, you need to talk to an employment lawyer. You need to talk to somebody like us at helpemploymentlawyer.ca or 1-855-821-5900 to get a proper legal analysis, employment legal analysis of your employment contract. That said, at a high level, by default, as an employee, once you've been terminated, you have a right to common law severance. Common law severance is simply a judge evaluating how much severance you're entitled to. So this is a without cause termination. It's very important. That clarification. Common law severance is a judge evaluating how much severance you're entitled to pursuant to your age, your length of service, the nature of your employment, how long you're unemployed for, and what your employment contract says. The gatekeeper point, starting line, is what your employment contract says. The reason why it is because, and common law severance, could be quite generous. It can be, depending on how long you've been in a location, it can be up to 2 years, it can be 24 months. Okay, at your salary. So it can be quite generous. But you have this presumption to common law notice. The parties can choose to contract out of it into something else at the time of contract formation. And why would they do that? Why would you do that? Well, you do that because the employer says, "Hey, Carrie, you want this job? Okay, well, sign. If you want this job, you have to sign this contract in exchange for the job that limits your severance upon termination to the lowest amount or something else, but usually the lowest amount we can offer you at law, which is I'm simplifying, but it's about 1 week per year of service to a maximum of 8 weeks if you're provincially regulated." Okay, so you can see a situation where, given your length of service, you could get 24 months, but in fact you're limited to 2 months, right? Because of what's in your contract. So these things really, really matter. So now there are various ways to get out from underneath it, or from the employment contract, which is why you need a lawyer to look at it. But as I was saying, your employer is going to try to contract out most of the time of your employment contract of the presumption of common law severance into the Employment Standards Act minimum. So what you're looking for is language about the Employment Standards Act generally, if you're provincially regulated. But Carrie, you got a new contract. I'd strongly kick the tires on having a lawyer look at it. Okay, JC is back. How are the dollar figures for human rights damages calculated? Good to see you, JC. I always enjoy your questions. It's a great question. The answer is no idea. The dollar figures for severance are calculable, or at least assessed pursuant to a formula. Your age, your length of service, the nature of your employment, availability of similar employment, put those into a blender. You can estimate ranges. Okay? There's a lot of judicial discretion, so the ranges can vary widely, but you know sort of where it's going to be, and then you can make decisions about your legal position from that. Okay, that's common law severance we're talking to. Human rights damages, you're talking about compensation for injury to dignity. So discrimination you've experienced based on your age, race, ethnicity, sex, sexual orientation, gender, etc., disability. How do you quantify the affront to your dignity, the injury to your dignity? I don't know. Right? So the tribunal human rights tribunals just sort of figure it out based on the egregiousness of the conduct, right? So more egregious, more money. The damages tend to be smaller, but there was famously, I think it was in BC, there was famously a huge decision. I think it was $700,000 for ongoing racism that occurred. I want to say it was in a prison. I can't remember exactly. It was a prison worker. I can't recall specifically, but they are getting bigger, and it just depends on the egregiousness of the injury to dignity and the conduct of the employer um, in terms of what those damages are going to be. But it's really, I mean, the answer is we have no idea, right? Just more egregious, more money; less egregious, less money. I'm sorry I don't have a better answer for you, JC, but no one can really quantify what an injury to dignity is worth. So, but yeah, no, it's a great question. Okay, I'm not going to say this person's name because it's unique. What kind of changes can my employer make to my position or pay before I'm allowed to object? Okay, so you can object to anything, but the question is it in your best interest to object? Because number one, it's going to damage your relationship with your employer. Number two, does your objection de facto terminate your relationship with your employer such that, or acknowledge a constructive termination such that severance damages flow from it? That depends on what your employer has done. So, standard answer is if your employer reduces your pay, your compensation by 20%, then that's a constructive termination of your employment. There are cases that say 10% has been fine. If it's only 10%, you got to assess whether or not that 10% for you is worth it. It's a historically tight labor market, so for a lot of you, you have more power now than you've had in 20 years, if not more. And so maybe you just want to pull the trigger on your constructive dismissal, get your money in, and then look for another job. Although it seems to be changing with these layoffs. Corporations seem to be hesitant with respect to staffing up, given the impending recession that most believe is coming because of our inflationary woes. But in terms of your pay, it's about between 10 and 20%. 10 absolute floor. I wouldn't go. It's a 5% pay cut. You don't have a constructive termination. But remember, you object, you've effectively acknowledged your termination. You're done. You don't get to work there anymore. Okay, so I mean, in reality, if you say to your employer, I'm not okay with this, and you keep working there, then you're still working there. But if you then contact a lawyer later and try to go after your severance, your objection is effectively your termination, and then the time that you continue working there counts against your severance, right? So, if too much time goes by, your severance claim is effectively worth zero. So it's really just, I object and I'm not working there anymore. But you can't do that without talking to a lawyer. So, and I'll give you all the details again one last time in a minute. Yeah, so 10% floor, but I would talk to a lawyer first. And then the second part of your question, position. All right, so a demotion is a constructive dismissal, 100%. But it has to be a demotion in which your job is effectively, is a significant decline in prestige or duties, like your job has been hollowed out and you're just a figurehead now, or you were the manager of a department and now you're a supervisor of one person, right? You're a manager of 40 people and now you're a supervisor of one person, something like that. Okay, and so whether or not it is a constructive dismissal is an evaluation of the facts and how severe the change is, and how long you were in the other position. If you're there for a year and then you got demoted, then maybe not. So again, you're going to have to talk to an employment lawyer, but I would never make an objection before I talk to a lawyer. But here's the other thing. This is the thing you have to remember. You have 2 months from the change to try on the change before you're deemed by law to accept it. I have a case in BC that says, I should say I have a case, but I use a case in BC that says 3 months. That was found 3 months, but Supreme Court of Canada found it, said at 2 months was fine to trigger constructive dismissal. And so you can't sit on it forever. If they lower your pay and demote you, talk to a lawyer right away, because you've got the clock ticking. You got 8 weeks to figure it out, okay, and make your objection. So try it on, and if you don't want to continue in the position, then make your objection and you trigger constructive termination. So before you go, I almost said your name, before you do anything, talk to an employment lawyer, but do it fast, because you have a finite amount of time to pull the trigger on your objection. So with that, I've answered all your questions. Thank you for all of them. They were great. You can reach us at employmentlawyer.ca, help at employmentlawyer.ca, and as always, 1-855-821-5900. And join us on Monday. I think it was Monday with Chris Justice. I think the Chiron's going to jump up now. There we go. Monday, Chris Justice, the aptly named Chris Justice at 1:30 p.m. Eastern Time. He will be answering all of your questions, all things employment law. He's great. So come join us for that. And I don't think I will be here in 2 weeks. Every 2 weeks I'm here, but I don't think I will be here in 2 weeks. I'll have to check my schedule. If not, it'll be a week or two after that. And I look forward to seeing all of you then. But thank you for all your questions. They were great. Have a continued great and safe summer. And I look forward to our next session. Thank you.